Good afternoon, sir.
Good afternoon.
Mr. Recaldin, we were on the topic of dispute resolution. I'd like to bring up onto screen your sixth witness statement at page 67, please, paragraph 185. You address there some figures in relation to dispute resolution. It may be that they're slightly out of date now because they were based on the position as at the time you wrote the statement. Actually, sorry, before I get to that, just to say, in your evidence earlier, I asked you about calendar days and working days. And it's been brought to my attention that where you use the term days in your witness statement is calendar days rather than working days.
Thank you.
If we have a look at that dispute resolution procedure section, it says, of the 2,720 offers made, 532 have been disputed. It says 86% of legally represented applicants dispute their offer, compared to only 11% of non-represented applicants. So it's much more likely that there will be a dispute where somebody is legally represented. Is that correct?
Yes.
If we go over the page, please, to 185D, you say there remain 383 unresolved disputes with an average time in dispute of 14 months, of which 261 have not yet gone through a good faith meeting. Some feedback from legal representatives is to bypass the good faith meetings and go straight to the next escalation stage to speed up resolution, which is why the process is approached with a degree of flexibility. Average time in dispute of 14 months. I mean, that's a very significant time period, isn't it?
Yes.
And what do you say is the principal cause of that delay?
I think, well, there are a number of things. Could it be done quicker? Yes. I think in this part of the process, however, it's really important that we have continuous engagement with the legal representation and also with the postmasters, and that inevitably causes delay. Your term, I call it a process, but I understand why that can be viewed as a delay. So that is deliberately put in there, the 261 that haven't yet gone through a good faith meeting, because there are legal advisors who say we were not in dispute, we just want to understand more. So we want to understand the offer better, and we're waiting for advice from our clients about whether or not it needs to enter into the dispute process. So it's almost like a waiting room until the legal advisor gets clarity from their client around whether or not it is a dispute or not, and that's why they've yet to get to a good faith meeting. However, there are cases, quite rightly, where the good faith meeting is bypassed, and that's why the process is flexible, and the opportunity is there to go straight to a face-to-face escalation meeting.
Can you assist us? You have there the average time. Do you know how long the longest time period for a particular case has taken?
No, I don't, but I know I would be very embarrassed to know what it is.
Because it may be years.
I take it that there are cases still unresolved which were part of the cohort of cases which began within the original time frame, which would mean that we're 4 years down the line, wouldn't it?
From May 2020, when they may have been submitted, yes, Sir Wynne.
Yeah.
And do you think that's a handful, tens, hundreds?
Not hundreds. But certainly tens, yes.
Thank you. If we could please go over the page to page 69. We have there the proportion of offers disputed by date of first offer. And it looks as though in parts of 2023 into the beginning of 2024, you have somewhere approaching half of the offers being disputed. Is that right?
Yes.
And we see there towards 45%, for example.
Yes.
We'll get to the letter from Dr. Hudgell shortly, but one of the complaints that was made in that letter is that the escalation meetings are difficult to secure and don't lead to tangible follow-up. I think you've reflected on the number of meetings, of those escalation meetings, and you've said that there will be a further increase in their frequency. Is that correct?
Correct.
Do you recognise that those meetings have been difficult to secure?
I have to say, Hudgels and Post Office have worked, what I think, collaboratively together consistently. And I don't believe getting dates into diary, if that's what this means, has been a struggle. I don't believe that is the case. I think I'd like to think we're very collaborative in terms of getting those dates in diaries.
One of the cases that they highlighted was a case where a figure was agreed, but there had been months of argument as to which head of claim that amount fell under. Is that something that you are aware of?
I am aware of that case, yes.
And what are your views as to what I would call delays in that particular case?
I'm disappointed, and we need to be better at it.
Are there plans to resolve that?
Yes.
Imminently?
Yes.
And what about the resubmission to the panel? Does that build in further time?
Yes, it does. The resubmission to panel is a bit of a consistency, because the panel provide that consistency and that optic of the fairness of the outcome. And it's, we believe it's an important part of that process for that consistency and for absolutely that independence. But we also recognise that could lead in delay. There's another legal review requested in terms of a resubmission into panel. It then has to wait for their next panel meeting, then they opine, and then the recommender. So it takes, that's a process that does take time. And we recognise that to avoid that, we are now offering an opportunity that instead of going back to panel, we can have a face-to-face negotiation directly with the legal advisors and the postmasters. And
since when has that been in place or communicated?
So that's been in place consistently, or has always been there, but we've always followed the process of going back to panel. Not every time, but we have a commercial flexibility in order to settle. But most of the time we do go back to panel for that consistency perspective. So in terms of additional flexibility and allowing the legal advisors to make the call, and obviously their clients, that is something which you will have noticed that was in my correspondence to Dr. Hudgel last week.
So that's a relatively new process.
Yeah.
I won't bring back the survey onto screen, but in the results, more were dissatisfied with the dispute resolution process than satisfied. I think it's small in numbers, but 16 against 4 who were satisfied. Again, do you have any views on that?
I'm disappointed, but not surprised.
We then have the arbitration level. That's for claims over £10,000. Is that correct?
So we've never experienced an arbitration, and the £10,000 is now effectively is ineffective now because of the 75,000 scheme of the offer. Again, we've never actually been to an arbitration, so we've never sort of formalised that process at all.
Thank you. In terms of an appeal mechanism, there's been discussion about an appeals mechanism. Can you assist us with what the current plan is for that?
The appeals mechanism was actually came out of this inquiry. And Sir Wynne and the inquiry very helpfully suggested some areas that the inquiry might bring forward for attention, such as the fact that consequential loss principles were issued after the scheme was launched, the fact that legal representation was not supported at the point of submission of claims. And Sir Wynne very, very helpfully listed a number of questions and challenges around what could be the implications of these. So Post Office, doing their best to listen, if I may say that's inquiry, went away to consider those challenges and those issues and said, and how could we address those? And at the same time, actually, the advisory board also came forward to advise the Department of Business that in their view, that an independent appeals process for HSS cases would be appropriate because of the inherent mistrust, I use the word, the inherent mistrust of anything coming out of the Post Office. that might be slightly unfair on the advisory board in terms of their advice. And at the same time, because of the challenges that Sir Win and this inquiry gave us around these issues, we thought, well, actually, a resolution to all these issues could well be an independent appeals process. So even if cases have settled with us, then actually, if the recipient, the victim, feels they've had an unfair outcome, despite the fact it's from an independent panel, etc., then they have a right to an independent appeals process.
And has that been implemented?
So the government actually announced its intention to bring that forward. I think under Minister Hollingworth at the time, I think in March of this year, it was announced in the House of Commons. We then had purging and we had an election. And therefore, new ministers had to be appointed and new ministers had to be brought up to speed. And I understand, and there has been an announcement in the House, that the new minister is also supportive of such an appeal scheme. So that has formally been announced. The actual process behind that is being built, I understand. But again, Post Office are willing to help, are helping to build that, but that has to be independent. It cannot be tainted with Post Office. I completely understand that.
So
and that'll be run by the government.
It'll be run by the government. Who's building it at the moment?
So the Department of Business and Trade are building it, as I understand, as we speak.
Have you made any projections as to anticipated take-up of that mechanism?
No.
Do you have a view as to how likely it is or not that the numbers are going to be of significance?
I think through the helpful YouGov survey and our live experience, I think we can help very much in what that may look like. And although it has not been agreed, one step that has been discussed in this appeals process is the potential transfer of the dispute resolution process into that appeals process. Hasn't been agreed. It's one thing that is being considered.
In terms of the overall perceptions, as you've said, they're set out in the YouGov survey. Perhaps we could bring that up again. That's EXPG 607, page 67, figure 50. Page 67. If we scroll down, we can see overall satisfaction levels. And I think this is something that may give you, as you say, an indication. We have there figures for those who said that they were fully informed at every stage of the process. Net dissatisfied 48%, that the scheme was easy to understand and navigate. Net dissatisfied 49%, that you had enough information to make informed decisions. Net dissatisfied 52%. With the HSS overall, net dissatisfied 49%. With the time it took from starting your application to reaching the end, net dissatisfied 48%. With the amount of compensation received, net dissatisfied 43%. And as you can see there, that was 1,430 respondents to that part of the survey. Again, do any of those surprise you?
What maybe I could hopefully to help the inquiry is they disappoint me again, but they don't surprise me. My experience away from the Post Office in remediation schemes, this sort of feedback is not unusual, unfortunately. It's just not unusual. It's remediation. Something has gone badly wrong for anything like this to be active. And boy, has it got wrong in this space, right? Absolutely gone disastrously wrong. And therefore, any recoup from that position is always going to be a struggle. So, yeah, the figures are just not good in terms of, 49% are overall dissatisfied. 51% might be partially satisfied. And that's what, in a remediation scheme, that's what you have to hang on to in terms of the positive. So, I'm very disappointed, absolutely, but not surprised, simply because of the nature of my experience before Post Office of remediation schemes.
Thank you. That can come down. If we address issues of delays, you've already addressed them this morning. You've set them out in detail from paragraph 104 onwards in your statement. I won't bring that back onto screen. I'll just go through one by one of the various reasons you give for delays. The first is the issue of funding, and it's a matter that you've already addressed today, that, for example, panel members are only appointed in June 2020, funding sign-off from the Department for Business and the Treasury was not until March 2021. So am I right to summarise that in your view, one of the reasons for what I call delay, what you call process, is issues with funding?
Yes.
Second, you referred to high volumes of applications and their complexity. You say that the 2,548 claims by September 2020 was unanticipated. I think that's also the evidence effectively you gave this morning. Is that right?
Yes.
There's been complexity such as taxation issues, the official receiver and bankruptcy issues, issues with creditors. Can you very briefly summarise those kinds of issues for us?
Well, when you any activity where you are required to engage with a third party, then an education process has to take place, and you are dependent on the third party. So bankruptcy is a great example, and insolvency, etc. So that will always take time to feedback in how you're going to deal with those cases. If I may, the one thing not on that list is the governance around the establishment of the process, the drawing up of the principles, and we talked this morning around HSF and the panel assisting us, and indeed we need to include the government in that process as well, in terms of drawing up all those principles and those processes and getting them all signed off at a multitude of levels. I think last time I counted, there are 12 stakeholders that I need to keep happy, and in particular in this very sensitive space. That is a challenge for any organisation to be able to do, to keep those 12 stakeholders engaged and comfortable and have a say in a process design.
Thank you. Sticking though with the bankruptcy issue, you've addressed that in your 8th witness statement, and perhaps that can be brought up onto screen. It's WITN 09890800. It's page 3 where the issue of bankruptcy is addressed. You say there, in relation to claims concerning bankruptcy, there are 56 outstanding claims which were made between the 1st of May and 27th of November 2020, all of which have received an offer. 15 outstanding claims which were made between 28th of November 2020 and the 31st of December 2023, and 87 outstanding claims which have been made since the 1st of January 2024. Is this a particularly problematic group of cases?
That's not the feedback I'm getting. I mean, clearly there's a separate process for bankruptcy cases. We need to understand what the bankruptcy court are interested in terms of their take on this. And we do split the heads of loss that we can pay directly to the postmaster, and ones that we need to be committed to the bankruptcy courts, etc. So it hasn't been raised to me as a particularly troublesome area. But again, and I know we will get onto it, a number of in particular the 87 may be resolved by the £75,000 process.
Thank you. That can come down. I'm still going through the various reasons you give for delay. The third is shortfall analysis. I think we've already dealt with that, and you've said it could possibly be sped up by just looking for one shortfall rather than multiple shortfalls in future. The fourth is later applications. So the scheme reopened in October 2022, and you had 230 claims waiting to be addressed straight away. So those are ones that had been stacked effectively. Is that correct?
Correct.
Following the Mr. Bates ITV drama, there were 1,345 applications between January and May 2024. So a large number of applications. Paragraph 120 of your 6th statement, you accept that you were not resourced for that increase in January 2024. Can you elaborate on that, please, for us?
Absolutely. So until that point, we were effectively planning closure of the HSS, and indeed had a tentatively agreed date with the government about when we would close the scheme, simply because we knew how many late applications we were getting in, and therefore could project how long the scheme needed to last for. Now, we'd have still issued a reminder for people to come in if they wanted to, but it was clear from the traction that we were getting and the numbers of new claims coming in that it was deteriorating. They were coming down to a handful a week. And therefore, we were planning to effectively close the HSS scheme with government permission, etc., etc. So we downsized the people accordingly. Can't have people sitting around not doing anything. So both HSF and Post Office started decreasing the number of people on the scheme.
So in terms of your staffing and support, what was your team size as at, say, December or the very beginning of January 2024?
Beginning of January, it will be a circa 200.
And how has that changed since then?
We're now increasing significantly, as I said earlier. We're now recruiting in order to anticipate the peak of activity that we have. That said, we're also automating, and therefore we're going through a careful planning process around the people we potentially release through automation. We're using, hopefully we're going to transfer their capabilities, their abilities to other areas of the business.
If I can pick you up, though, on the recruitment, I think your evidence was the recruitment process is taking place now.
It is.
The increase in numbers took place in January, February 2024. Were you doing anything about those numbers in the intervening period?
So the numbers in 2024 are the consistent numbers that we've had in the RU remediation unit across. That's been fairly consistent. It's only the recent recruitment where those numbers are going up.
But in terms of the number of applicants, that shot up. We saw those figures after the ITV drama.
Yeah.
Did the number of people within your team shoot up accordingly? Or is it just more recently that you have turned your mind to increasing numbers in your team?
More recently, in terms of the impact of those cases coming through.
And why do you think it is that thought wasn't given to increasing numbers before now?
It has been, and forgive me, I was talking about Post Office, so don't forget a lot of this process is within Herbert Smith, and they had downsized and they had started increasing at that time. So in early 24, they were increasing their numbers to deal with the peak.
Thank you. The fifth reason you give it is agreements pertaining to tax treatment, interim payments, eligibility, bankruptcy and insolvency. Under that heading, you've also discussed issues with having to liaise with the Department for Business and Trade. Is there a figure at which you have delegated authority to settle cases without having to refer them or refer matters to the Department for Business and Trade?
Yes.
Is that something you're able to give an indication of? Is it most, some that fall within under that?
Very good question. I would say some.
But in the majority of cases, you still have to go back to the department for authorisation.
I would say more than that. Well, certainly, and I'm absolutely guessing here, but it feels like a sort of 60% still need to refer to further authority levels. So I haven't been. My authorities matrix is very complex. And I certainly haven't been given the mandate to settle at whatever cost. That would be wrong as well. But I haven't been given a complete flexibility in that, no.
And do you think the level that it is currently at is too low, too high, just about right?
In order, looking at the cases that we need to resolve, I would say currently it's too low.
And are steps being taken? Have you had discussions with the department about this?
Continuously.
And are they open to changing that?
Yes.
Do you foresee that changing soon?
I hope so, correct.
The sixth, and one that we're going to come back to and possibly spend quite a lot of time on it, is the legal representation and legal representation costs. Those costs have only been available since October of 2022, is that correct?
Yeah.
They're not available at the application stage. They're only available at the offer stage. Is that correct?
That is correct.
Could I please take you to page 39 of your sixth statement? So that's WITN 09890600, page 39, paragraph 127. So you say at paragraph 127, some applicants have instructed legal representation from the beginning of their application process. While the data shows that this makes a minimal difference to the eligibility outcome, we have received proportionately more consequential loss claims as a result. Although available to all upon request, the data appears to show legal representation has also been a driving force in applicants receiving an interim payment. So it seems as though those who do instruct their own lawyers are more likely to claim for consequential losses and are more likely to claim for interim payments. Is that a fair understanding of that paragraph?
That's a very fair understanding of that paragraph.
And does that not suggest that the ability to claim for those might not be sufficiently identified to those who don't have legal representation or sufficiently known by those who don't have legal representation?
I think that could also be a fair conclusion. If it helps the inquiry, if I may step back slightly, and I think the inquiry will recognise that the GLO and the activation of the scheme, the term legally light has been used quite a lot because the GLO membership was so burnt by the legal process which they were forced to go through to get the absolute right outcome for them and for the other postmasters as well. And therefore their insistence was that if for any other scheme would be legally light. And that's why the HSS was originally built that way, to say, well, we want to make this a legally light process and therefore you don't necessarily need legal advice for the submission, but you can have legal advice when the offer is made. Now, and we'll support that. That was the theory behind why there wasn't legal advice. Now, I recognise the optics coming out of my own statements and indeed the YouGov, etc., it's pretty clear that statement is accurate by looking at the data. The applicants who do have legal representation apply for more consequential loss heads of loss accordingly.
And as a result, do you think a lesson learned is that actually legal representation at an earlier stage could positively benefit the scheme?
I think it can, but again, please, it's not defensive at all. I struggle, therefore, with why 83% seem to be satisfied, and the vast majority of those without legal advice.
When you say satisfied, we saw from the survey results they weren't necessarily satisfied. What you mean is 83% accept the offers.
You're absolutely right. I apologise. They have settled.
Yes.
And therefore, I just struggle with that sometimes. But I'm sure you will go on to the fact that the ones who are legally advised at the offer stage and beyond, their average redress is greater as well. And I absolutely get that as well.
I think you've said that the background to that is that the sub-postmasters wanted it to be legally light. Is it not also part of the story that the Post Office and Department for Business or whoever else was involved in designing the scheme may also have wanted to avoid having lawyers at an early stage in order to save costs?
I think that was probably a consideration. I wasn't there, but I think it probably was a consideration.
One thing that you've said at paragraph 139 is that it's regrettable that the Post Office didn't send the consequential loss guidance to all potential applicants. Have you done anything to highlight what consequential loss is, to publicise its availability to those who may not be aware?
Yeah, I mean, it's comprehensively covered on the website, and we direct everybody to that. We also have a customer care line, in fact, a customer support line when postmasters ring in, legal advisors ring in, and we can point them in that direction.
We'll come to that. So that was your sixth reason, legal representation issues. Seventh, in terms of delay or time that things have taken, is the dispute resolution procedure. That can come down, but at paragraph 130, you say, when the applicant rejects their offer, this is often the time when the applicant obtains legal representation, and that's meant that further information is then presented, new heads of loss. So when somebody instructs a lawyer, which is only available as of right once an offer is made, then they may, for example, provide new information or further heads of loss. And that, again, builds in time to the process. Reflecting on that, doesn't that justify the instruction of lawyers at an earlier stage? Because if you had that information or those heads of loss at an earlier stage, before the offer is made, that might avoid the delay or time taken after the offer is made.
I cannot see a flaw in that.
I think you say in your statement that it elongates the time that it takes to settle as a result of
Correct.
that new information. Moving on now then to the fixed sum offer and the top-ups.
Before you do, Mr. Blake, have you left the topic of appeals? Because if you have, I just want to ask one or two more questions about that before you start another topic.
Yes, please, sir. Please do.
Right. Mr. Recaldin, perhaps we could have paragraph 139 of Mr. Recaldin's witness statement on the screen, and that's at page 42. And this is simply to give us a reference point, really, Mr. Recaldin, for the point I want to pursue with you. You will see that the second part of this paragraph actually deals with what an appeal may deal with.
So we're just waiting for it to come up onto screen.
Yeah, sure.
Thanks. It's page 42.
Right, so I'll come to this paragraph in a second. Let me just ask you one or two basic questions to make sure I got it right. The possibility of an appeal process was first mooted earlier this year and not before that. Is that correct, Mr. Recaldin?
There was a recommendation from the advisory board. Forgive me, Sir Wynne, I don't know when, but it was before March this year. And there was a recommendation from Post Office about the same sort of time as well for an independent appeals process.
And then the government announcement was March this year.
I think so. That was, yes. It was Minister Hollingworth.
That's fine for these purposes. And I'm right in thinking from what you've said that the appeal process will be both formulated and administered by the department, not by the Post Office.
You're absolutely correct, Sir Wynne.
Right? But this is now coming to the nub of what I want to ask you about. Since March 2024 to the current date, has the department, in inverted commas, consulted with the Post Office, as far as you're aware, about the grounds upon which an appeal might be brought?
No, since March, yes, they have recently, Sir Wynne.
And when you say recently, do you mean within the last few weeks or what?
I do mean within the last few weeks.
Right. So there is still work to be done, if I can put it in that way, in formulating what might be regarded as at the heart of any appeal process, namely, upon what grounds can you bring an appeal?
Correct.
Right, okay. And I use this paragraph 139, because in it you say that the post office hopes that the appeals process might assist with remedying people who were unaware that they could bring, say, consequential loss claims.
Yes, sir.
Yeah. So there's still a great deal of uncertainty, am I right, about the basis upon which any appeal can be brought?
There is uncertainty on the basis of which appeals can be brought currently, yes.
And does that uncertainty extend to having to decide whether the appeal process will be open to everybody who has thus far participated in HSS, regardless of whether they've settled or not? Or is there still a debate going on about which category of HSS claimant might be eligible to appeal?
I think that is being discussed, whether or not it's open for everybody, or whether my words, so whether there's a filter on that, on what types of applicants can apply to it. I think that is yet to be determined.
All right. Well, when Mr. Cresswell gives evidence on behalf of the department, he may be able to place more flesh on this particular bone. But doing the best you can, does it look to you as if we are some months away from formulating both the criteria for bringing an appeal and the process for bringing an appeal, and therefore some months away from this appeal process beginning?
So when on the limited engagement I've had with the department on this, I understand there is a strong appetite to have something up and running in the new calendar year.
Well, those are very carefully chosen words, if I may say so, Mr. Recaldin, because something up and running in the new calendar year could span from January until December, couldn't it?
Okay, let me be fairer. Let me be fairer to the government's Department of Business and Trade. Again, the limited engagement they've had with me and my team is that they are certainly under pressure in order to produce a process, and the articulation, the verbal articulation they have is that they are under pressure to be able to do something, to announce something in terms of a process in Q1 of the next calendar year.
All right, thank you. I wasn't trying to tease you, Mr. Recaldin. Do you know if, just if you don't, please say so, but do you know if there has been any consultation between the government and any groups representing postmasters about both the likely grounds of appeal and the process generally?
No, I don't.
Fine. All right. Thank you very much. Sorry, Mr. Blake.
Not at all. Thank you. So we'll move on to the fixed sum offers and top-ups. As you've said already today, that the average that was paid was originally £52,000. And from the 9th of August of this year, a fixed sum offer of £75,000 was introduced and is also provided as a top-up to those who had already settled for a figure below that. So we have top-ups to those who have already settled that increase the amount that they are provided up to £75,000. You have an offer to those who haven't yet settled for £75,000 for any figure, an offer of £75,000, and you also have are communicating this offer to those who haven't yet applied for any redress. Is that correct?
Correct.
Can you briefly explain the background to the 75,000 and whose idea it was and where it came about?
So the background of the 75,000 was effectively a minimum payment introduced into the new GLO scheme, which, as we know, is operated by DBT, Department of Business and Trade. And the government recognised straight away, as the Post Office, is that if that was being offered in the GLO space, it would be absolutely appropriate to also offer the same in the HSS space. But as ever, there are differences between the GLO scheme and the HSS scheme. So grateful, willing to adopt that, but of course we had to incorporate that into new processes because the HSS cohort is a different cohort to the GLO cohort.
If you accept the 75,000, are you foregoing other rights? And including, as Sewin has said, in terms of those potential appeal rights, might you be foregoing those appeal rights?
So, and this is why I articulated the differences between the GLO and the HSS, is yes, you're absolutely right, as you mentioned earlier. By accepting the 75,000, you are waiving your rights to a future appeal. So you would call it delay, and I understand that. One of the reasons for delay on the 75,000 was we had to take a step back and say, well, actually, how are we going to operate that in the HSS scheme? Because what we prefer to do is one communication to all the postmasters and past postmasters who had not applied to say, here is your opportunity to apply. Here is what the £75,000 scheme looks like. Here is a closing date. And here is the details of the appeals process. So if you decide to accept the 75, you are waiving your rights to this appeal process, and this is what it looks like. Now, because of a timing issue, and I have to say that the election was probably something to do with it, that appeal process was not built sufficiently enough to be able to be communicated. And therefore, all we can talk about is a future appeals process that is going to be built. But in my view, quite appropriately, we still felt we had to get out there with these offers. It's all about timely redress, because we're falling short on the timeliness of this redress. So therefore, it's not the best piece of communication. I accept that, to say, here is your top-up, here is your offer of 75,000. However, but by taking it, you are waiving your rights to appeal process, which isn't built yet. And I understand the optics of that. I absolutely understand the optics of that. And we have spoken at length to government about those optics. I call them risks. And the government are aware of our concerns around that. Nevertheless, everybody felt it's still appropriate to launch the £75,000 scheme accordingly.
So an individual may accept the 75,000 figure now in the knowledge that they are foregoing an appeals process that is not in fact yet developed.
Correct.
You've also addressed in your 8th witness statement the letters that have been sent out. You say 266 letters have been sent out to those whose applications have been recently received and the post office considers may be appropriate. 54 of those have already been paid. Can you tell us very briefly about the assessment? How have you assessed that certain current applications may be appropriate for that £75,000?
Well, because their claim, we've looked at that claim, and their claim appears to be under 75,000. So that feels like an opportunity. So we've ring-fenced that population, that cohort, and we've proactively gone out to them and said, would a 75,000 offer satisfy your claim? We've had a very interesting and a very prompt response to that, which is really encouraging. And we continue to do that with the existing cohort. And we've got a positive response back in many cases, and we turned around. So as soon as they sign their offer, they're presented with an offer. As soon as they we pay within 10 working days.
Letters have also gone out to applicants who have received but who haven't accepted offers of less than 75,000. Is that correct?
Correct.
And there's also a mass mail out that either was just about to take place or has taken place.
We started it. It's up to 30,000. I can't send 30,000 out on the same day, but we are ramping that up. So we're at hundreds now. This week we'll send thousands. Next week we'll send. So we're ramping all that up to cover the 30,000 population.
To be sent to 30,000 people.
Circa 30. It depends on that. We were doing all the data analysis on the population. Yes.
Thank you.
So up to 30,000.
In terms of the top-up payment, those letters are also being sent out to those who settled for less than 75,000. Again, have they gone out? Are they about to go out?
They've gone out.
All of
Gone
them
out.
have gone
Yeah,
out.
and we've on that population alone, we've paid out 87 million.
And I think you've said in your 8th statement that 1,194 top-ups have been accepted. Presumably that's also increased since
Yes.
the date that that was written.
Yes.
And you've noted that 85% of settled claims have settled for less than 75,000. There might be a suggestion that those delays that we've seen in the process in 2024, you don't call them delays, but we saw the figures, the charts, the bars quite high as at the current period. It might be suggested that there is a delay being built into the existing claims in the hope that people will accept those £75,000 payments. What do you have to say about that?
I think that's fair. I think there has been an identified an exercise. I know there has been an exercise that's gone through on that population to say, is there a part of this population who you think will be appropriate to offer the 75,000, and therefore once we've got the funding in place, we can jump on that straight away. Absolutely, yes.
But do you think that has actually resulted in a delay to the processing of their applications through all the stages that we've talked about?
No, I think it's actually sped it up, if I may be so bold, because they won't have to go through the full process, the full legal analysis, the full HSF review, and the full panel session. So hopefully we go slow to go fast.
But those that are awaiting a panel session, for example, awaiting those various stages and meetings, is any consideration given to the fact that it might be that those are cases that will accept the 75,000, so we won't be progressing them to those various stages?
Absolutely.
There is?
Yes.
And can you expand on that, please?
So again, we look at the entire population that have made a claim, and if we believe, if the claim is for under 75,000, or we believe they may settle for under 75,000, we will approach them all to say, this is a new thing. Is this something that you would be comfortable with accepting, given that you'll be waiving your rights to an appeal, etc. And if you hear all the details, and if you're comfortable with this, let us know, and we will immediately make you an offer of 75,000. So they can interject into that process at any time they want.
Do you think that that is fair to those that are awaiting an imminent panel hearing, for example, or panel decision, that their cases might now go back slightly in the queue because you're waiting on the response to that £75,000 offer?
I don't think it's as timely as that. I don't think that would be a delay. And they have the right to continue with the process which they're on. We're not stopping that process. We're just giving them another option which they might want to consider. So I don't see that. And again, if they're queuing up for panel, and I actually see if they are prepared, if 75,000 is a good offer for them, I still would see that as being a quicker redress than going to panel and waiting the 30 days from panel to offer letter, etc., etc.
But just so we're absolutely clear, is there a conscious decision on behalf of the Post Office to not take forward those cases?
No. So only with their permission, only with Postmaster's permission.
Could we please turn to Bayes 40763? This is the minutes of a meeting with Minister Hollenrake on the 30th of April 2024. We can see there that you are one of the listed attendees. If we scroll over the page, please, there's a section on compensation. We have a couple of versions of this document. There's a slight change made to the minute, and I'll take you to that. But there's a discussion of compensation here. and it records as follows. Simon, is that yourself?
That'll be me.
Yep. Simon explained the message from us on OC2. Is that the new overturned convictions process?
HCRS.
Pardon?
HCRS.
HCRS. Happy to help. He noted that they are communicating with Charlotte and Carl's team, need to clarify within acceptable time about what that disclosure looks like. Full disclosure, big job and very expensive. Minister Hollenrake noted that he was hopeful that a lot of these people take the fixed sum award route anyway, and you say even to a place where no disclosure at all. And then this is the bit that is changed in the subsequent note. It says, how can I advise my client that £600,000 is good enough given no disclosure? The amendment in the later version, which I can take you to, says it's making clear that you're saying that claimants will say, how can I advise my client?
I'm trying my best to identify a risk that the government might face in terms of something that a legal advisor might say to them. How do I know that? How can I advise my client if £600,000 is a fair offer if I have no disclosure? I don't know.
Absolutely. I mean, this is not in relation to the current scheme we're looking at, but I just want to take you to some words from yourself within that meeting. So we have what you've said there, and it says, Simon said that they're hoping to help with capture, open and willing to let accountant in to have a look. Also, they are keen to see HSS appeals, that whenever it is ready. Minister Hollenrake says, still waiting for HMT, I think. Carl Creswell agreed with the minister and noted that we're working with the Post Office to see if we can do the £75,000 top-ups, not new cases in the meantime. And that's the issue we've just been discussing, I think, in relation to the appeals process and the £75,000 offer. You say there, penultimate entry, Simon, current proposal on the new £75,000 is to do it in-house and not use the services of Herbert Smith Freehills. Is that still the case?
As in my statement and as advised earlier, yes.
Thank you. If we look at the amended version, that's Bayes 40764. It's not significantly amended, but if we look at the bottom of page 2, we can see there that the issue that you posed is, Kevin noted that he was hopeful that a lot of postmasters whose convictions are overturned by the bill will take the fixed sum award route away, and you respond even to a place where there's no disclosure at all, and this is the risk that you're highlighting. Claimant lawyers may ask, how can I advise my client that £600,000 is good enough given no disclosure? Doesn't that also apply to the £75,000 figure that we're talking about in relation to the HSS scheme? If your plan is for that to be a quick process, doesn't the risk that it's not going through that disclosure process, that it somehow bypasses that process, isn't that risk present here?
Yes.
Is there anything that you plan on doing about that risk, or is that just a risk?
I articulate that risk in a slightly different way, if I may. That is the legal representation at the claimant stage, effectively. I think you called it disclosure. I say that it's legal representation at the offer stage, and I'm sure the inquiry have seen the documentation around this. Post Office have pushed hard on this with DBT. And I'm sure Carl will support that as well. The evidence is there. We've pushed hard on this in terms of wanting to have understanding the optics of having legal advice at the claimant stage from the perspective. DBT currently, their thinking is not aligned with that. In terms of funding that, everything has to be funded, of course, and it's taxpayers' money. In terms of funding that, and everything is under continuous review, but at the moment they're saying they want to stick to the current process.
So is your evidence that in respect of the £75,000 fixed sum offer or top-up, the Post Office's position is that it would be preferable to have legal advice at the early stage, whereas the Department for Business's position is different to that.
I don't want to elaborate on a difference of policy between. That's not my job. Is to get redress out to postmasters as quickly as possible. I really cannot afford and don't want to get involved in sort of internal politics. But I need to answer your question, okay? And the Post Office's view has always been in this cohort that we should offer legal advice, to pay for legal advice in the offer stage, i.e., learning from our lessons from the original cohort.
You say at the office, do you mean prior to the office?
Prior to at the claim stage, at the claim stage, and the evidence is there, and I'm sure the inquiry have seen it. The number of times I've written to the department to ask them to reconsider that position, and they haven't. Do
you know why? Is it purely funding? Is it something more than that?
I do believe, and I think I articulated before, I do understand. I try to be balanced. I understand that so if somebody's got an offer, and people who talk to me regularly will be bored of me saying this story. If people have got an offer of 40,000 and they've settled and they're satisfied, I appreciate your definition of satisfaction is different to mine. They've settled at 40,000, and then they get a letter saying, we want to top that up to 75,000, sign here. I can understand why they may not need to necessarily think twice about obtaining legal advice. I get that. And certainly the process is not designed to encourage legal advice. And so, to make it simple and slick, fast, and get redress out the door, which is my job, I can see how that can work. I worry when the legal advisors come to me and say, hang on a minute, how can I advise my customer, my client, whether that is a full and fair? And that's a risk to me.
Yeah, thank you. That can come down. Thank you. Moving on to interim payments, you've addressed that paragraph 22 of your sixth statement. I don't need to go to the actual paragraph. At first, it was £10,000 limited to those in poor health or seeking or suffering from financial hardship. Is that correct?
Correct.
Those limits on availability were lifted in October 2022.
Yeah.
And since July of 2023, interim payments of up to 100% are available to applicants who have received an offer.
Correct.
Does that mean 100% of the amount that you're offered you will receive straight away, irrespective of whether you contest it further or not?
Yes, if you ask for it, yes.
Thank you. What is the situation in respect of those who haven't received an offer in respect of an interim payment? How is that calculated now?
So we do offer interim payments prior to offer, upon request, and particularly in hardship cases, but it's not limited to hardship cases. And we have a process where, as long as we've identified the shortfall, it's the amount of the shortfall we go up to that we can pay out. We don't get many requests for pre-offer interim payments. In fact, very, very few for pre-offer interim payments.
How is that now going to work with the £75,000 offer? If essentially people are getting £75,000 as of right, albeit risking certain rights such as appeal rights, does that justify a greater interim payment to those who contest the £75,000 and say that their claim is worth more?
So that's where the jeopardy comes in. And it's important that the inquiry understand that, is that if they decide not to take the £75,000 offer, and subsequently their claim is gone through the independent panel, etc., and comes out at less than 75,000, they'll get the lesser figure.
And reflecting on it, do you feel that there should be or shouldn't be some sort of increase in the standard interim payment for those who are contesting, in light of the fact that they are contesting, but they have rejected a £75,000 offer?
Well, it depends if they've got an offer or not. So if they've got an offer already,
They get 100%.
yeah, I have strong views. As soon as an offer goes out, it's not post office money, it's not government's money, it's postmaster's money. So as soon as that offer goes out, they're entitled to the lot. The dilemma I think you're articulating extremely well is the dilemma of when you haven't got an offer, the 75,000 has been rejected. So that's a pre-offer interim payment, and therefore we would go back to the shortfall.
Exactly.
Yes,
And
that's right.
looking at the £75,000 figure that's now going to be offered, do you think limiting those interim payments just to the shortfall figure is sufficient and is right?
I think it's consistent, and it supports the jeopardy that government clearly want to put in that place to say you've got an opportunity for 75,000, but if you don't believe that's sufficient, there is a risk that once the case has gone through the full assessment, the risk you face is it might be less.
Thank you. Could we bring up onto screen your sixth witness statement at page 56? It's paragraph 167. I just want to understand some figures that are given there about interim payments.
Yep. Yep.
Thank you. So it's page 56, paragraph 167. You say there, in total, 474 interim payments have been paid to 312 applicants, 7% of applicants. Of these, Post Office have offered 174 single payments, equating to 100% of their offer, with the balance being partial payments, and 23% of complex applicants receiving an interim payment, compared to 10% for standard applicants. Can you assist us? More interim payments have been made than there are applicants. Can you help us with that, please?
Yeah, absolutely. It is confusing, and our apologies, there is a confusing paragraph. So an applicant can have a number of interim payments. So they may, even if they may have an offer, and they offer, let's say, is £100,000. They say, I'm going to go into dispute. In the meantime, can I have 50% of my offer? Of course you can. So we pay out 50%. They then may come back a few weeks later and say, well, actually, can I have another £25,000? Of course you can. You can have up to 100% of your current offer. Now, during the dispute process, for example, the offer might go up a few times. And every time that offer goes up, they're entitled to another interim payment up to that offer amount. So that's why there are more offers than cases.
Is there a number that you have for interim payment applications that have been refused? I think that 7% of applicants is referring to total applicants, isn't it? It's not referring to applicants for interim payments. Are there a large number, a small number, some...
Small, tiny
number that are refused?
I think, to be fair to them, again, a lot of these are legally advised, and the legal advisors understand exactly the process, and therefore they are advised absolutely appropriately.
And if we scroll down, we can see there in paragraph 168, you say, overall, 4% of those without legal representation have received an interim payment, and 64% of those with legal representation have received an interim payment. A very significant gulf between those who are legally represented and those who aren't. Again, that suggests possibly that the message isn't being communicated effectively to those without legal representation. What's your view on that?
I think that's always going to. I think that's a fair observation. I think the availability of interim payments is well known. It is on the website, etc., etc. So it is out there, and I know every case that goes into the dispute resolution process, they are all written to say these interim payments are available to you. In particular, around hardship, it's very clear that the interim payments. But I do understand we could always do more publicity and prompt it more I do accept that feedback.
If we scroll over the page, please, we can see a chart there for the average days from interim payment request to payment. So that's the processing time of those interim payments. We can see even this year, it's nearly a 6-week wait from request to actual payment. We've seen again the number of applications increasing. That's something we looked at earlier in terms of 2024 figures. What gives you confidence that it'll either stay the same or reduce?
As advised in my statement, we are going to adopt much of the automation and the efficiencies around the £75,000 process. This will come down significantly.
I won't take you to our expert report again, but it's page 58 of that report. Lots of red again in terms of satisfaction levels with the interim payment process. I assume your answer to that is the same as before, that you understand it and something you recognise.
And disappointed.
Yes. Returning to legal fees more broadly now, if that can come down, please. The BAT, below assessment threshold cases, are they provided with any legal advice?
So they are made an offer, and therefore at the offer stage they can still have a legal advice. They're all the same.
Are you aware of what kind of proportion of those cases actually take legal advice?
No, I'm not. But of course that has now been taken away by the 75,000.
Yes. You've explained the background to why legal fees are only available at the offer stage, or why that was formulated. Previously, there was £1,200 for legal advice, where the offer was less than the sum claimed. Is that correct?
Yes, that's right. Yes.
And there was a small amount, only £400,
£400
for where the offer was for the entire sum or for more. Those caps were removed from all offers made from the 10th of October 2022. Is that correct?
That is correct.
Applicants are now entitled to what's called reasonable legal fees. Is that different to legal fees available in the GLO scheme, where there are fixed sums for legal advisors?
We try and work collaboratively to the ranges in the GLO, and we have used those, yes, but we still base ours on reasonable. So there have been a number of occasions when, and I have been given authority to exceed whatever reasonable is, but I take legal advice on those. So we are still, we do use the GLO guidelines as guidelines, but there we are still we have reasonable fees.
If we could go back to your sixth statement, please, and turn to page 10. Paragraph 27, you give figures for the average legal fees. It may be quicker if I just read it. It says, the average legal fees prior to the 10th of October 2022 was £3,044, and after that date it was £4,575. Can you assist us with that difference, why you think it is that those figures have changed?
Just the submissions from the legal advisors. That's I'm very comfortable with them.
If we could please turn to page 66. Paragraph 184. Thank you. We see there that the take-up of legal representation is low, 12% in respect of those who have had offers, 16% if you include legal support rather than legal representation. Why do you think that take-up is low?
I really don't know.
If we go to page 63, please, paragraph 181. If we scroll down, you say there that in almost all instances, a legally represented applicant receives a higher offer, even within the same applicant types.
Correct.
Can you see an issue there?
I do, okay. Absolutely.
And what's the issue?
Well, claimants are generally, the vast majority are not taking up the offer of free legal advice funded by the Post Office. And yet the stats are clear that when they do have legal advice, they get higher payouts. I absolutely understand that.
If we go to page 64, there's a table. And we see there in 2024, for example, in complex cases, similar in 2023, it's almost double the figure where those individuals are legally represented. Is that something that you were aware of before compiling this chart?
I think this makes it much more transparent, but yes, I was aware.
Yes. Does that in some way suggest that representations, further pushing from people representing individuals is necessary, and that actually the Post Office on its own isn't coming up with the right figures?
I wouldn't call it pushing, I would call it representing.
And why should that be necessary? To drive the figures up by, in some cases, double?
Because they're representing their clients, and their clients are providing a position for them which they are asking to be represented. I do see it as an issue. Again, in my mind, I struggle with this. I absolutely get it, and that's the reason, one of the major reason why Post Office recommended, following Sir Wynn's prompt, around an independent appeals process, where people, if they feel dissatisfied, now they see these statistics, the transparency that this is provided, and thank you for doing it, actually, do they feel they have an unfair offer? Subject to Sir Wynn's challenge around, well, what's the parameters of that appeal? Who qualifies for the appeal? If, in the way that I've articulated to government, and government, have accepted this, is that if they believe, and the advisory board more importantly have said this, if they believe they've had an unfair outcome, and seeing these stats, they may feel they've had an unfair outcome, then they have the option for the appeal process.
One thing we spoke about earlier was legal advice at an early stage. In the GLO schemes and the overturned conviction schemes, we understand that solicitors can commission a report, such as a forensic accountant report, from the outset. Might that, first of all, speed up this process, and secondly, as you've highlighted, have an impact on the final figures? And why do you think there is that difference of approach?
I think there is an aspect of trying to keep this as legally light as possible. I understand that. A lot of the feedback, in fact, I noticed in the YouGov survey as well, there's a lot of feedback about this is too legalese. Why can't we just cut a deal on this and make it a much more simpler? I get that from many of the legal advisors as well. Why do we have to go through this process? Why can't we go into and just shake hands on things? So I think I'm not trying to counter it, because I'm absolutely agreeing with you, but I think there is this other aspect still that I still grapple with, about how can we make this as simple and as unlegalistic as possible.
Thank you. Before we take our afternoon break, I'm going to take you to that letter from Dr. Hudgell that we've spoken about. It's HUJ, I think it's 6 zeros and then 7.
This is the new bundle, yeah?
Yes. It's a letter of the 23rd of October of this year. So a very, very recent correspondence between yourselves. Thank you. The letter includes various examples of the differences between original offer and revised offers. If we scroll down, please. These are in respect of those who Dr. Hudgell represents. We see there at number 2, for example, the original offer 46,000 in December 2021, a revised offer of 140,000 by November 2022. Number 4, we see from £4,000 in the original offer to £133,000 within the space of, it's taken 2 years. The original offer July 2022, the revised offer September 2024. If we scroll over the page, number 8, we have there an original offer of 363,000 and revised 2 years later to 649,000. Very significant increases in these figures. Number 11, 298,000 to 421,000. 13, 260,000 again to 420,000. So quite similar increases in those 11 and 13 from 200 to 400,000. Do you accept that there are big changes in these offers and the revised offers?
I absolutely accept them and think it's great.
Number 9, we see there the original offer 42,000 in August 2022, 45,000 by May 2024, and we understand that that now stands at £171,592. So a dramatic increase, despite the fact that that figure not really changing very much between 2022 and 2024. What's your view on that?
My view on that is that the legal advisors are doing the excellent job that they do, and they are gathering the information required for enable the panel, in many cases, if not post office, to increase the offers based on the evidence that is provided with the help of the legal advisors, maybe by forensic accountants, by medical reports, etc., etc. So I think the legal advisors are doing exactly what they should be doing and doing a brilliant job at it.
Isn't something going a bit wrong, though, that there have been such dramatic leaps in those figures, taken so long to negotiate?
So I think there are two separate issues here. In something going wrong, no, it's going right, because the evidence is being found in order to increase those offers to get to the fair redress. Timeliness is a separate issue, and I accept that challenge about how long it's taken. But and you know, this is a two-way street here. We like to work collaboratively with the legal advisors and make it clear to them what would help the case. Many of these cases, of course, all the cases have originated from the independent panel. That's where the original numbers come from, and many of these cases go back to the original panel. So again, they work within their terms of the panel work within their terms of reference to come up with these new offers. So they are basing it on evidence that has been produced by the postmasters and the legal advisors. So this is a process taking too long, but it is working.
It's working for those who are, in this case, represented by Dr. Hudgell and represented by others. But if we can turn back to the YouGov report, that's EXPG 607, and if we look at page 52 of the YouGov report, it addresses legal advice. Page 52. We have there only 33% of respondents said that they had been informed of their right to obtain legal advice. Only 10% were provided with information about how they could contact a legal representative. If we look at the bottom of page 52, the author says, reflecting the low awareness of the right to obtain legal advice, just over 1 in 8, 12%, actually received legal advice during the application process. Amongst those that did, 11% received financial support that they felt was sufficient, but 63% did not receive financial support. And we can see the chart over the page, please. Actually, if we turn, yes, figure 39, received financial support for legal advice during the application process. Overwhelming majority didn't, and that's reflected in your own figures. If we go, please, to page 55, even in respect of those who received financial support for legal advice when they received their offer, you have there 29% saying no financial support received for legal advice when they received their offer. There is a net yes, but 23% of those felt that the financial support was not sufficient. Looking at these and looking at your own figures and looking back at that letter from Dr. Hudgell and the impact that lawyers have had in that particular case, and I think you've really already given your evidence on this, but do you think that something's going a little wrong there in respect of the availability, the take-up of legal advice, and the impact that it may have on those who may have received offers or those who are awaiting offers?
Well, I think the first sentence is on page 52 of the YouGov survey. It says 1 in 3, 30% recalled having been informed of their rights. So that's their recollection of being informed about their right to obtain legal advice. The evidence which the inquiry would have seen is that everybody is offered legal advice at the offer stage. So this is, and again, I don't want to project this sort of corporate image because it's not a corporate image. It genuinely is not. But the offer of legal advice is there at reasonable costs. I haven't turned anybody down in terms of the amount of legal fees. I've had the odd discussion with legal advisors about their bills, yes, but we've never fallen out about it. And so the offer is always there. It's the take-up is the issue. And I think the challenge, quite rightly, from the inquiry should be how much have you pushed the fact that the benefit of legal advice. That should, maybe that's the challenge that I should go away and consider, because it's clear from the stats, as I've said earlier, my evidence is my evidence, is in that there's clearly a benefit of it happening. But to be clear, the offer is there.
And how do you think you can improve that situation?
By being more upfront, as more I possibly can, by making sure the clients are yes, they are my clients. My clients are aware of that opportunity. Again, I still struggle. I've got an 83% acceptance rate. I need to grapple with that. And where people appear, I'm not going to use your word anymore, they appear to want to settle at that rate.
Thank you. So that might be an appropriate moment to take our mid-afternoon break.
Yeah.
Could we come back at 20 to 4, please?
Certainly, yeah.
Thank you. Thank you, sir. Mr. Recaldin, my last question in relation to the historic shortfall scheme concerns an end date. When do you expect it to close? Is there a date fixed? And has a date been publicised?
Expectation, don't know. Is there a date fixed? No. There has been discussions prior to the election about when that date might be. And we did propose a date, which was sort of tentative. Nothing's been agreed, nothing's been accepted, but it was understood when that date might be. But then, of course, we had a peak of late applications, etc. So the date that was originally discussed was actually March 2025, and we've been advised by government that might still be being considered, but let's not take that as a date that will be publicised. So yet to be determined.
And is that a date for potentially the application process to stop or the entire scheme to finish?
Applications to be in by.
Thank you. One thing that you've mentioned is the Postmaster Contact Centre. You've addressed that in your witness statement. You say it opened in September of this year. Can I clarify, is that simply for the HSS scheme or for all schemes?
It's for whatever the postmasters want, so it will be for all the schemes. Currently, it's predominantly to do with HSS because that's the incoming, but we also mandate outgoing calls as well to be helpful and proactive. In the fullness of time, it will absolutely be anything we can do on the OC side as well.
And what steps have you taken to publicise that contact centre?
It's available on the website and available via correspondence.
Would it surprise you that some sub-postmaster corps participants were not aware of the centre until receiving your witness statement?
It wouldn't surprise me at all.
In light of that, is there anything that you have in mind that you could do to publicise it more?
So in the mass mailing, which we've currently started, is absolutely included on that. So there will be huge publicity because of the up to 30,000 letters that are going out is included in that. And they all point to the website as well in terms of where that number is available, including, and also any outbound calls, they are effectively publicising their availability to take inbound calls as well.
Thank you. I'm going to move on now to the overturned convictions redress. It's not known as, internally at least, as the overturned convictions scheme. Is that correct?
Correct.
On the 11th of December 2020, the first 6 convictions were overturned by Southwark Crown Court, and then the Hamilton judgment was on the 23rd of April 2021. By the 22nd of August of this year, you say in your 7th witness statement, I think, 111 appellants had successfully appealed their convictions and therefore fell within this scheme. Is that correct?
That is.
And they fall within this scheme and not the historic shortfall scheme because, as we saw in the eligibility criteria, it doesn't include those with convictions.
Correct.
There is, however, another category also included in this redress. I won't call it a scheme. What do you call it if you don't call it a scheme?
Process.
Redress process. And that is those who were prosecuted but not convicted and who aren't postmasters and therefore also fall outside of the historic shortfall scheme. Is that right?
Correct.
What about those who weren't prosecuted but who received cautions?
They are included in that cohort. Prosecuted, not convicted, they are within that cohort.
Thank you. So not convicted extends not just to those who had a trial, but also those who simply received a caution.
Caution, correct.
In terms of government funding, you've said in your witness statement that became available in July 2021. Was that difficult to obtain?
No.
But that led to interim payments of £100,000 at that point in time.
Yes.
Or from that point in time. And then there was a second funding agreement in December of 2021. Again, was that difficult to obtain?
I wasn't around, so I don't know, but my understanding was it followed the process and it was put in place.
Could we please turn to poll 004489114? As you say, this is before your time, but this is the funding commitment as at 22nd of July 2021, communicated by the Department for Business, Energy and Industrial Strategy, as it was known then. If we scroll down, please. It says the funding commitment letter confirms that the Department for Business will provide funding for Post Office to make interim compensation payments of up to £100,000 to each postmaster, branch manager and or assistant who have their criminal convictions overturned by the Court of Appeal or the Crown Court due to unreliability of evidence obtained from the Horizon IT system operated by the company. Over the page, please, it sets out there the funding structure. And it says each interim payment, which shall be no greater than the aggregate of £100,000 per any one affected postmaster, will be eligible for BAYS funding to the company, provided the postmaster meets all of the following criteria. 1, their Horizon-related conviction has been overturned by the courts, and that's why we see the scheme doesn't involve those who were recently received the change following the legislation. Number two, they do not belong to the class of postmasters whose convictions were overturned but were not opposed by the company on public interest grounds. Now, at this stage, that was an additional criteria, that it couldn't have been any of those cases that weren't opposed by the public interest on public interest grounds. Can you briefly explain your understanding of that?
So, public interest cases, and there are five of them. So these are cases that go to the Crown Court at Southwark, and when the case is made to it's a quirk almost of the Southwark Court, in that the cases that go forward, you can either support the appeal, or you can the alternative is a retrial, and clearly a retrial is not in the public interest, and therefore by default you are going to a case where you are supporting the appeal of the conviction, or you're raising no evidence against it.
And in those cases were originally not included in the scheme, but they are, I think, since following the Mr. Bates ITV drama, there was a change in that position. Is that correct?
There was a journey to get there, but yes, that is correct.
When you say a journey, what was the Post Office's position?
Because of this funding agreement, even though those three cases that I mentioned earlier, their convictions were overturned, but because of the funding arrangement, they couldn't be paid their £100,000. So despite Dr. Hudgell asking for it, the funding arrangement will not allow us to do it. So you've got cases which have been overturned by Southwark Court, and yet, because of the funding arrangement, they weren't entitled to their £100,000 because technically they weren't Horizon-related cases. And that was an awful position to put anybody in. And so we had to work our way through that, and we went through mediation to do that, and we reached settlement with two of them. Subsequently, due to the Bates and the mass exoneration, those cases have now been reopened and now back in OC.
So I think you said there were 5 individuals. What is the current status of those cases?
All those 5 are within the OC. I think one of them has been settled.
Thank you. Could we please turn to poll 004489115? This is the second letter of 20th of December 2021, and it's the funding commitment letter that confirms the department will provide funding of up to 685 million to the Post Office when aggregated with the funding committed under the interim payment funding commitment letter. The total funding amounts to 780 million, and then it sets out below the criteria. So those who have their criminal convictions overturned following the common issues and horizon issues judgment issued in the Post Office group litigation and or the Hamilton and others judgment issued by the Court of Appeal, or were prosecuted but not convicted of offences connected to the Horizon IT system and suffered detriment in respect of the actions of the company. Am I to understand, therefore, that that has now changed and we should add to that a third category of those who received cautions? Because they wouldn't have been prosecuted but not convicted.
My understanding is cautions are included.
Are you aware of any formal change to any agreements in that respect?
No, I'm not.
If we go over the page, please, to the bottom of the second page, it says there, the department has agreed to fund the claim payments made by the company to fulfil BASE's commitment to delivering compensation to postmasters fairly and as quickly as possible, and supporting and maintaining the Post Office network. It continues a couple of sentences on. This funding commitment letter specifically covers the provision of funds for claim payments for the OHC liabilities only, and is provided to support the company in delivering its rescue and restructuring plan. Can you assist with how the redress for these cases relates to supporting and maintaining the post office network or the rescue and restructuring plan?
I'm sorry, I can't help you there.
That can come down, thank you. Let's move on then to interim payments. Interim payments under this scheme were introduced in July 2021, as we've seen, for £100,000. They were increased to £163,000 in November 2022, following representations made by Lord Dyson, who was carrying out the early neutral evaluation, which we're going to come to. Is that correct?
Yes, it is.
More recently, it's increased for those who don't seek what is referred to as a government offer, and that's the £600,000 payment, which we're going to come to as well. It's been increased to £450,000 as an interim payment at the request of Sir Gary Higginbottom. Is that correct?
That's my understanding.
You've set out in your seventh statement, paragraph 122B, that the average time between submitting interim payment applications and the payment is 34 working days. Is that correct?
That's my recollection.
So let's look at the government offer. Since the 18th of September of 2023, there has been an offer of £600,000 to all overturned conviction claimants. Is that correct?
Correct. Correct.
Correct. That doesn't apply, though, to those who are prosecuted but not convicted. Is that right?
That is right.
Can you assist us with why there is that difference?
Because the difference is the actual conviction.
In respect of the rights, and we spoke about this in respect of the HSS scheme, am I right to say that the £600,000 is only available to those who don't seek a full assessment of their claim?
Correct.
You've said in your seventh statement that by the 31st of May of this year, there were 40 accepted cases. And you've said that the average length of time from receiving the offer to payment is 20 working days. Is that all correct?
Yes, that's right.
Pardon?
Yes, sorry.
Thank you. Could we please turn to Bays 0000719, please? 40719. This is an email chain. I want to ask you about your initial views as to the £600,000 government offer.
Yep.
If we turn to page 4 of that document, the background is, I think, that Herbert Smith Freehill have drafted a letter relating to the £600,000 figure. Is that correct? Or a letter has been drafted by somebody. If we scroll, please, to page 4, we can see some of the background. Do you recall this chain where you're commenting on a statement that's being made in respect of that £600,000?
I recall, I saw this email the other day. I do recall the email. I recall its construction. I cannot recall it as a result of a letter.
Well, perhaps we'll go through it in a bit of detail. If we start where we are, this is a email, if we scroll up slightly, from Emily Snow, who is a member of the Post Office compensation team in the Department for Business. And she says as follows. She says, you'll spot comments in both attachments on pitching as a DBT-only intervention. I appreciate that it is a DBT proposal and that the timescales at which we're working have meant that we haven't been able to do the type of engagement and ironing out of issues that would have been preferred, not least by the Post Office. However, I'm somewhat cautious about the language, which goes quite far to pitch as a DBT proposal without showing some interaction between the Post Office and the department, as you'll see in the core text. This is from a view that we don't want to create a perception that the government is stepping in because it has lost faith in the Post Office process. This is not the case at all. We should send a positive message. There are two good options for postmasters: £600,000 or remediation, which the government supports, since postmasters who do not wish to accept the upfront offer will still need to go through the remediation process. I think the wording should uphold the faith in that post office-led process. There's then a response, and we see there, it's the email below from Neil McDade that says, by way of an update, Herbert Smith Freehills have crafted a high-level heads-up letter to claimant representatives, which the department have commented on. They've also provided comment on the core lines to the post office. And it's above that that we see your response. And it's that response that I'd like to talk to you about. You say as follows, you say, care with the statement, please. You're absolutely right. This does read as a DBT proposal without showing interaction between the post office and DBT. As apart from you and an email exchange between myself and Carl, that's, I think, Carl Creswell, initiated by me, there hasn't been any. Of course, will create a perception that the government is stepping in because it's lost faith in the post office process, as this is precisely what it is. I don't think we should be disingenuous. We have to be honest and transparent here. It's clear from this and the lack of risk assessment to the Secretary of State that the government nor the advisory body have any faith in post office. This will come up at the inquiry with government nowhere to be seen. The paragraph of most concern I have lifted and pasted below my comments in red. If we scroll down, we can see you've lifted a paragraph from this statement and commented on it. So it was going to say government having consulted with post office, and your feedback is false, delete. Only you have kindly told us the bare essentials, and then to a highly restricted audience, this is not consultation. It then was going to continue, has decided that postmasters who have their convictions on the basis of Horizon evidence overturned should have the opportunity up front to accept an offer of £600,000 in full and final settlement of their claim. This will be delivered by the post office with funding from the government. And your comment there is, this implies this is extra funding, and again is disingenuous. This is not extra funding, as you know. The funding is already in place. It's just a different, hopefully more efficient way of paying it out. In fact, a quick look at the post office accounts will show to anybody who wants to see that we are anticipating in paying out in excess of this average. This is where consultation would have helped. Just pausing there before we continue with this, can you assist us with your position as set out there?
Yes.
Please do.
So I think the 600,000 opportunity was brilliant. I think it was an inspired idea in terms of how to speed up redress. It was, I think I'm clear in my note, it's the way that it was imposed on post office, and yet we were told that it was clear in the correspondence that they had consulted with post office. Government had not consulted with post office. My statement is clear. I was told about it literally in a quarterly shareholder meeting we had. I was advised that it was going to be launched the next day. I knew about it probably 24 hours before then, because I did request DBT whether or not we could see the press briefings around it, and I think I was politely declined that as well. So it was all shrouded with secrecy in terms of its actual launch. There was no, but post office were expected to operationalise it, manage it, and push it through. So, and that came out in my note. There was no consultation, which can be fine. It doesn't mean to say it's not a good idea. It's still a good idea. Don't get me wrong. And it came directly from the Secretary of State, and that was one of the reasons why we believe that it was confidential, etc., etc. It was kept under wraps because it had to make an impact, and a positive impact.
Why do you raise a concern about the extra funding being disingenuous, or reference to extra funding being?
Because the impression that was given by the statement was that government had proactively found additional funds in order to be able to do this. And that was not the case. The funds, as I articulate, the funds were already available. It's just a different way of doing it.
Thank you. Do you have a similar view in respect of the budget announcement that's just happened in respect of the extra funds?
Forgive me, my job is to pay out redress as fast as I can, and I know I'm being challenged on that, and as much as I can. I really do not, my preference is massively not to get involved in politics with a small p and a large p. You know, but I have to answer your questions, and there are elements in this, and there are obviously elements in the Chancellor's thing that are political, and I find myself in a really, really difficult position around that, because the politicians with a capital P are taking the opportunity, and that's their right, they're politicians, that's what they do, to take advantage of that to, I don't know what, to give themselves publicity, to give themselves credit for whatever. This 600,000, to your point, is a Secretary of State decision.
Thank you. We'll move on. You say, I suggest we change to government has decided that postmasters who have their convictions on the basis of horizon evidence overturned should have the opportunity up front to accept an offer of £600,000 in full and final settlement of their claim. You say, I think this is damaging enough and is a bit more like the truth, please. I think somebody has to try and cling to some morals here, please. This is an imposition and it should not be flowered up in any other way. The Department for Business, the Secretary of State should take the credit for this initiative. Let's not forget that this will be exposed at the inquiry, where this will be seen for what it is, a clear political intervention into a post office scheme with good/excellent intent, but simply not thought through, which is how the legal representatives will view it. Interestingly, despite the common interest and direct request, Post Office have yet to be extended the courtesy of seeing the legal advice given on this, on the scheme we have to run. Does any actually exist? What do you mean by simply not thought through?
Well, the allegation that we were consulted, the Post Office were consulted when we weren't, and part of not thought through was we immediately started asking questions around what does this 600,000, is it a minimum payment? And it became apparent it wasn't a minimum payment. Oh, right, okay, so how are we as the operational people going to administer this? And there were questions that we were posing that had yet to be worked out what the answers would be. In addition, with the greatest respect to the legal representations in this room, is that I had a couple of phone calls from them wanting to understand. And to my point about the politicalisation of this, I got 2 calls from legal representation sitting in this room before I was advised of this scheme to say, this is about to be launched. What's your comment on this, this and this, please? How is this going to work and how is this going to work? And I'm afraid I had to say to them, I don't know because I'm not aware of this scheme. I'm not aware of how we're going to operationalise it. Bear with me. That's embarrassing. Bear with me. I will come back to you as soon as I know the answers. So that's where that comes from. And there was some publicity around this because effectively that population out there of convictions, it became immediately apparent that the spin on it was that everybody was going to get a minimum payment of £600,000. We had direct approaches from very distressed postmasters that because the people knew they were in that cohort, and that they knew they were making a claim, they were going to get £600,000. And we did have reports of people actually knocking on their door about it, and that was quite distressing. And I got that feedback through the legal advisors as well. Do
you mean that they were concerned for their safety or for being chased for money from third parties?
To that point, the vast majority were anonymous. And yet, if anybody knew they were making a claim or part of the scandal, then they knew that that effectively this was saying that they're going to get a minimum of £600,000.
You continue. For your information, we have had a pecuniary claim in from Hudgels at the end of last week for 18,000. Their non-pecuniary was settled for 195,000. Under this proposal, this individual will enjoy £600,000. I'm not saying this is wrong, and you know I want to pay out these sorts of sums, but to date have been prevented by value for money restrictions, evidence, governance, etc. Just pausing there. Now, you addressed value for money at the very beginning of your evidence today, and you said that you didn't think that value for money restrictions were being imposed in respect of the settlement of compensation claims.
Yeah.
This reads somewhat like it did have a role to
Yeah, I could understand that it's not meant that way, but it's a list of processes, restrictions that I had to go through and governance that I had to go through. I do understand your point about, but no, please, value for money is not applicable in this.
You continue, at a stroke, all credibility/professionalism is gone. Never mind the months of work put in by Post Office and DBT on principles and working with postmaster lawyers. The inquiry will see all this. I have to assume all are comfortable with this. I'm not. It might be suggested that what you're saying there is you're not happy with the £600,000 scheme because, for example, in that Hudgels case, the Post Office could have got away with a lot less. What's your view on that? No,
I think that's the wrong interpretation of that. I've been clear in the paragraphs above that I think this is a good idea and this is exactly what I want to do. I think I can argue that sentence is more around the process that you have implemented, that you have agreed that I can follow, the governance that you have put in place for me that I have to follow, only allows me to pay out this amount. And yet, at a stroke, you're completely undermining that and saying, actually, you're going to get £600,000.
You say, am I the only one worried about all this? Is it me, or is this really Emperor's New Clothes stuff? I think we're sleepwalking into real difficulties. What did you mean by that?
Again, it's around these Post Office are an operational engine that delivers these outcomes, these fair outcomes. At a stroke, the government were undermining the confidence in that it says in here by saying that actually, effectively, we're uncomfortable with this process, and it's clearly not fit for purpose because it's not paying out enough, and therefore what we're going to do is we're going to impose this on, and we're not even going to consult about it.
Could we please turn to Bayes 40738, and now moving to January of 2024, and there's an email chain regarding whether it's a minimum payment or not a minimum payment. If we start on page 4, we see at the bottom of that page being forwarded to you an announcement from the government announcement, re-overturned convictions. Once this legislation is passed and convictions have been quashed, individuals will be entitled to at least £600,000 in compensation to rebuild their lives. The government has always been very clear previously that there's no minimum amount, although in reality the £600,000 up front offer set that floor. If they're saying publicly that individuals are entitled to at least I think that should be £600,000, it feels uncomfortable to me that we cannot make interim payments to that amount. Now, is this the overturned convictions process, or is this the other process?
So this is the new process from the £600,000 that effectively wasn't. So in terms of interims, we couldn't go up to the £600,000. It wasn't a minimum payment. It was very clear, to be fair, very clear that this was for full and final settlement only. So it's a bit like the £75,000. Here's £600,000, providing you are prepared to settle.
And if we scroll up, we can see correspondence between yourself and Carl Creswell. And you say, I know we're going through interesting times. Is that a reference to the post-Bates television drama? We're in January 2024.
Yes.
But further to previous mails, does not the government link below translate to the current £600,000 being a minimum payment? If so, we could pay circa 60 cases up to £600,000 with imminent effect. And if we scroll up, The response to you is the £600,000 is a fixed offer sum that postmasters can choose to take, or they can seek to make a fully assessed claim. It is not a minimum payment sum and therefore not suitable for an interim payment amount. There is a £163,000 interim payment to relieve any immediate financial pressures for those making full claim whilst that claim is developed and considered. Additionally, specific further interim/hardship payments are also considered if requested by a claimant. If we scroll up, you say, okay, Beth, okay, last go, I promise. I do understand the initiative, but it's not logical. We do need to, we do not have an expiry date on the £600,000 full and final offer. We await to hear on this. So currently there's no expiry date on this offer. If a victim decides to push their claim through full evaluation and their offer is less than £600,000, they will be advised to take the £600,000 in full and final. If their offer is above £600,000, they clearly will settle above £600,000. So whatever happens, they get £600,000 as per the mass exoneration scenario, nicely aligned. So whatever happens, they get £600,000. So alleviate postmaster stress and media outrage by being proactive and topple 60 up to 600,000 because they're all going to get that anyway. If we scroll up, the response to you is you asked yesterday whether the aim was to get money as quickly to claimants or to get full and final settlements to the claimants. Our focus is on achieving the latter. This proposal doesn't encourage any pace or movement to full and final settlements, does it? Ministers and politicians, as shown in the Select Committee, are keen to take steps to encourage victims getting their full and final settlement as quickly as possible. I don't believe this moves the dial on that. You respond, slightly above. Beth, so we hold the funds back that we could pay to encourage full and final. No need to respond, but grateful for your two responses. Last word, promise. What is the right thing to do? I've moved on. If we scroll up, we can see the response. The policy position regarding the 600,000 was announced by the Minister last year. Last week's announcement doesn't change that policy. You asked yesterday whether you should focus on maximising payments or maximising settlements yesterday. We were very clear that we would like you to focus on ensuring that claimants are able to settle their claims as quickly as possible, as this is what ministers and other politicians are keen to achieve. We need to ensure that victims can complete the claims process. The proposal that you have made does not speed up the overall claims process and indeed may actually further lengthen it. That is not fair to those who are still waiting to achieve full and final compensation, many of whom are coming up to their third anniversary of their conviction being overturned this spring. Can you assist us with this, what appears to be a dispute between the Post Office or yourself and the Department for Business?
I can. So, and it's pretty clear from the one below from the department around, there's a choice here between are you saying the objective is full and final settlement? Is that a priority over paying funds out? Because in particular in OC, there are many opportunities, as I explained earlier, to pay out more further interim payments. And what the department was saying to me was, no, we don't want you to do that. That's not the aim, that's not the objective anymore. We'd rather you hold on to those and hold out for settlement. I was extremely uncomfortable with that, and I think I'm making my point articulate what is the right thing to do, because I didn't want to delay redress. It seemed to me that I was getting an implication to delay redress in order to hold out for full and final settlement. I was saying, hang on a minute, I'm not quite sure I'm comfortable with that. If I've got the opportunity to still pay out redress, a bit like my example, if there's an offer there, I want to pay the offer amount. Then I don't want to feel restricted about not paying that out because I'm only going to pay out when I get a full and final settlement. That for me was quite a strong moral dilemma. And maybe I articulated it badly in there, but that was the moral dilemma that I was facing. And they made it clear to me, absolutely crystal clear, no, Simon, the objective is there, black and white, full and final settlement. So I then had to issue instructions internally to say those potential interim payments, government will not approve them now. And they didn't approve them because we were holding out for full and final settlement.
And what is the latest position on all of
It's
that?
changed.
How has it changed?
So government now appear comfortable that whenever we can make payments via a head of loss, for example. So there may be 10 heads of loss, and we may, the legal advisors and we may be comfortable with 8 of them. We can pay those 8 heads of loss, and we settle effectively via each heads of loss.
Does that extend beyond £600,000 potentially?
Can do, yeah.
And when has that change been in place?
Forgive me, I don't know when, but for some time. But this was the initial, and since then the position has eroded.
But can you give us an idea? Was it in the summer, in spring? This is January of this year.
Yeah, this would have been during the summer. Yeah.
Thank you. Moving on then, that can come down. Thank you. Moving on from interim payments, there's then a full assessment for those who don't opt for the government offer.
Yeah.
Claims are made of pecuniary, that's financial losses, and non-pecuniary losses, such as physical and mental loss impact. Let's start with non-pecuniary. You've addressed this in your 7th statement at paragraph 100. You describe the early neutral evaluation scheme that was set up in 2022. Lord Dyson was appointed to the role of evaluator, and he evaluated at that point 10 claims. And this led to Lord Dyson's evaluation of the 29th of July 2022, which set out the ranges of redress for various heads of claim. Is that correct?
Correct.
Lord Dyson considered matters again in December 2023 relating to whether the money from the group litigation order should be deducted. Can you summarise for us what his finding was in that respect?
Well, nobody should deduct the GLO payments that ought to be made from redress.
Do you know what the Post Office position was in respect of those GLO payments prior to that decision?
That we were deducting them.
And were you in favour of deducting them, or was there an internal discussion that you were party to as to whether that was the right or wrong thing to do?
I was aware of the policy, the process to do it. I wasn't involved in any debate about whether to do it or not. It was just accepted that their overall redress would be discounted by the redress that they'd already received.
Thank you. The Post Office, you say in your statement, has offered to refer 3 further cases to Lord Dyson for his own review, but that hasn't occurred. Can you briefly assist us with what that involved and why it hasn't occurred?
There are 3 specific cases. Forgive me, I think they all come from one legal advisor, and we are very, very keen where the legal advisor is not agreeing with the non-pecuniary offers that we are making. And in order to resolve those, we have suggested that we go back to Lord Dyson to help us evaluate, and we are extremely supportive, and we are trying to encourage that proactively. And as yet, we haven't managed to get the time in the diary from the legal advisor's perspective.
And is that something that Lord Dyson is happy to do?
Yeah, absolutely. We've even had previously time in his diary allocated to it.
Paragraph 75 of your 7th statement, you say that by the 28th of August of this year, 77 non-pecuniary cases have been fully settled, including some who accepted the government offer. Is that correct?
That's right, yes.
I think you say 77 non-pecuniary, 9 non-pecuniary haven't settled, 25 more expected but not yet submitted. Perhaps we can bring that onto screen. That's the 7th statement to WITN 09890700. That's paragraph 75. That's page 27. So that gives the figures there. 77 non-pecuniary claims have been fully settled. You also say in the statement that over 90% of non-pecuniary claims submitted were settled and paid within 44 working days of application submission. Is that right?
That's right.
It appears from your statement that the non-pecuniary cases that take a longer time is bankruptcy cases. Is that right?
Yes.
So whereas in the HSS scheme, I think you weren't particularly concerned about the bankruptcy cases and delay. Is there a concern there at the moment?
To be clear, for the inquiry, I am always concerned in any delay, firstly. And again, where the bankruptcy is involved, we just have to engage with a third party, and therefore that elongates the process, builds in delay.
And is there anything there that you think would speed up that process?
I think we're on this, and there will always be things that we can do to speed up redress. And if this is one of them, I'm more than comfortable to get involved. But at the moment, it's not being raised to me as a significant risk.
Thank you. Moving on then to pecuniary, you've explained that prior to establishing the pecuniary principles, it was a slow process. Is that right?
Yeah.
Those principles were established in October 2023 and finalised in January of this year. Is that right? We saw that non-pecuniary claims took an average of 44 days to complete. In terms of pecuniary claims, you've said 305 working days. So over a year in relation to pecuniary claims. Is that your experience?
Well, in terms of, but that my understanding is that will be including the building of the pecuniary principles. So that was a journey. So when, and I think Mr. Cameron's witness statement also sort of supported this, when I first arrived at Post Office in this space, obtaining settlement with postmasters on overturned convictions was a negotiation. Okay, it was locking lawyers away in a room and working things out on a heads of loss by heads of loss basis, and it wasn't constructive and it wasn't collaborative. And so the first thing I did, and Mr. Cameron's evidence sort of supported this, was I proposed a different approach, a remediation approach, very much a collaborative with the postmasters and their legal advisors to walk in the journey between us, all of us being a party to that. That took some time to establish, and then we built the principles based on that principle that this would be collaborative process. So the principles were with the legal advisors. Now, the legal advisor would never agree to those principles, but their input was very, very valuable, and we did adjust those principles with their feedback. So by the time we got to the October, and by the time we got to at the end of the 2023, we were in a position where we had a bunch of principles which people appeared to be very comfortable with working within, although they weren't signed off, that they had input from a number of third parties, including postmasters and, more importantly, their legal advisors. And that's what we shared all that journey all the way along through governance in Post Office and indeed with government as well, to ensure everybody was comfortable with the approach we were taking of that process. And there were some really good behaviours were seen by everybody in that respect, in getting to an outcome, a remediation outcome that we could take the postmasters through.
And I think you say in your seventh statement that full claims not involving novel heads of loss now take around 40 working days. Yeah. Is that right?
So we're absolutely aware that new nuances, new principles, new heads of loss will appear. And we have a process that wraps those in as well, which again have to go through governance. Now, as soon as a new principle or a new heads of loss has to be reviewed, of course, we have to understand the financial impact, and we have a huge modelling exercise that we go through to say, right, if you're going to now embrace that new heads of loss, to your point earlier, what's the impact on anything that you've already done? And what's the impact going forward, and how is that going to affect the financial modelling, indeed the provisioning, etc., etc. So all that exercise has to be done with government approval.
Thank you. Could we bring back up onto screen your seventh witness statement, please? WITN 09890700. It's paragraph 86 on page 30. Paragraph 86. As at the 28th of August 2024, all claimants except 3 have received a payment in some form, whether an interim payment or final settlement payment. These 3 claimants had their convictions overturned between late January and August 2024. All 3 have been sent an interim payment application form, with 1 claimant accepting the interim payment. This interim payment was made on the 2nd of September 2024. Can you assist us with how many pecuniary claims have finally settled and how many are outstanding, or an indication of that?
So what I can hopefully assist with, I probably have somewhere got the complete breakdown. I'm happy to supply that to you. What I can hopefully help the inquiry with, out of the 111 cases, because that's a fixed population now because of mass exoneration. So that out of the 111 cases, 61 have settled. The vast majority of those are the 600,000. But there are other cases that are above 600,000 that have settled. So 61 have settled. There remain 50 cases. Of the remaining 50 cases, every single one to this point in paragraph 86, every single one has had at least a minimum payment of £200,000. Many of them have settled on non-pecuniaries, and some of them have settled on pecuniaries as well. I haven't got that precise breakdown here. I think it is in my statement of as it was at the end of May. I'm happy to provide the inquiry with updated figures on that.
Thank you very much. So we're going to shortly break for the day. Mr. Recaldin is able to come back tomorrow morning, and we are able to accommodate Ms. Mumby to be completed within the day as well.
That's fine. Just 2 rather pedantic points, Mr. Recaldin. When you say that the number 111 is now closed, technically that may not be right.
Ooh, you're absolutely right.
In the sense that there could be non-convicted but prosecuted postmasters who would come forward still, and there could be, if you were right about this, postmasters who had been cautioned who have not yet come forward.
You're absolutely right, of course, Sir Wynne.
Well, he doesn't. No, I could be wrong.
No, you're absolutely right. Look, but in my head is absolutely the funding allows the prosecuted, not convicted population into the OC funding space. But because they're not convicted case, I haven't included. So in terms of overturned convictions, my understanding is a lockdown population. Thank you for the clarity. Yeah. You're absolutely right.
Yeah. But the reason I was thinking about that was, and I certainly may be wrong about this, I hadn't appreciated previously that cautioned postmasters were within OC. And when I was reading the section of your witness statement, which deals with prosecuted but non-convicted cohort, paragraph 29 onwards, don't bring it up now, I'll just ask you to look at it overnight. There's no mention of cautioned sub-postmasters, and I'm very happy that you may be right about it, but I would like you to clarify that for me, if you would.
Sir Wynne, I would appreciate the opportunity to clarity, and I think Mr. Blake also pointed out in the funding arrangement, it didn't refer to the word caution either. And as soon as I've said that, I'm now doubting myself. So I'm pretty sure it does, but I need to thank you for the opportunity for me to go and seek clarity. I will do that overnight.
That's fine. Thank you. Well, thank you very much for giving evidence all day. And I'll see you, I think it's 10 o'clock, Mr. Blake, tomorrow?
Yes, we can accommodate both Mr. Recaldin and Ms. Mumby tomorrow, even with a 10 o'clock start.
Right. Well, that's fine. And so I'll see you at 10 o'clock tomorrow morning.
Can I just clarify for Mr. Recaldin, obviously he can't speak to anybody about his evidence subject to that one issue relating to the caution.
Yeah, I think that must be right, Mr. Recaldin. You're not supposed to speak about your evidence unless I specifically allow you to do so, and certainly in relation to the clarification which I have provoked, you can speak to whoever you think is appropriate, all right?
Thank you, Sir Wynne.
Yeah.
Thank you, sir.